You need one, or you have it?
I don't have
Okay.
one. Okay, well, you can leave it in the right now. And that's what I would say. Compliant. You know? I am bound. I know about it. You see what I'm doing for me? I had to do that door. I told you about that. We're not quite sure. Everybody knows talking. Good morning, how are you? That's not how you work. You lean on the table.
Yeah, I know. I know. Yeah. So I don't, but I don't know how it's on YouTube. Sure. The first part of the time, follow to the order, but from what we've heard, from others, they don't know how that happens.
Short of it, it shows everybody, according to the one I promised,
We couldn't do that anymore.
that's all the officers, Natalia,
In the general.
Yeah.
Let's see, that goes all the way until today. It wasn't right today. It was smashed. I remember looking over the judge specific order. It's order is now.
I know 17.
No. I didn't do that the first day.
No, every day.
Are you with Jenny Clouds?
But if I want to think for Zoom. Right, at time.
Oh, yeah.
I didn't think I appreciate it. Thank you. Taylor.
Sorry? All right. Hold it back a second.
Maybe seated.
Yes, Judge.
So stipulated, Judge.
Now, ladies and gentlemen of the jury, the evidence and the arguments in this case are now finished, and I've now instructed as to the law. That is, I will explain the law that applies to this case. Remember that you have taken an oath, excuse me, to return a true and just verdict based only on the evidence of my instructions on the law. You must not let sympathy or prejudice influence your decision. As jurors, you must decide what the facts of the case are. This is your job and no one else's. You must think about all of the evidence and then decide what each piece of evidence means and how important you think it is. This includes what you believe, what each of the witnesses has said. What you decide about any fact in this case is final. Now it is my duty to instruct you as to the law. You must take the law as I give it to you. If a lawyer says something different about the law, follow what I say. At various times I've already been giving you some instructions. You should consider all my instructions together as a law you are to follow. You should not pay attention to some instructions and ignore others. To sum up, it is your job to decide what the facts of the case are, to apply the laws that give it to you, and in that way to decide the case. Now, a person accused of a crime is presumed to be innocent. This means that you must start with the presumption that the defendant is innocent. This presumption continues throughout the trial and entitles a defendant to a verdict of not guilty unless you are satisfied beyond a reasonable doubt that he is guilty. Every crime is made up of parts called elements. The prosecutor must prove each element of the crime beyond a reasonable doubt. The defendant is not required to prove his innocence or to do anything. If you find that the prosecutor has not proven every element beyond a reasonable doubt, then you must find that the defendant is not guilty. A reasonable doubt is a fair, honest doubt growing out of the evidence or lack of evidence. It is not really an imaginary or possible doubt, but a doubt based on reason and common sense. A reasonable doubt is this: a doubt that is reasonable after a carefully considered examination of the facts and circumstances of this case. When you decide the case and decide on your verdict, you may only consider the evidence that has been properly admitted in this case. Therefore, it is important for you to understand what is evidence and what is not evidence. Evidence includes only the sworn testimony of witnesses, exhibit admitted into evidence, and anything else I may have told you to consider as evidence. Many things are not evidence, and you must be careful not to consider them as such. I will now describe some of the things that are not evidence. The fact that the defendant is charged with a crime and is on trial is not evidence. Likewise, the fact that he is charged with more than one crime is not evidence. The lawyer's statements and arguments are not evidence. They're only meant to help you to understand the evidence in each side's legal theories. You should only accept things the lawyers say that is supported by the evidence or by your own common sense and general knowledge. The lawyer's questions to witnesses and my questions to witnesses are also not evidence. You should consider these questions only as they give meaning to the witness's answers. My comments, scrutiny, questions, and instructions are also not evidence. It is my duty to see that the trial is conducted according to the law and to tell you the law that applies to this case. However, when I make a comment or give an instruction, I'm not trying to influence your vote or express a personal opinion about the case. If you believe that I have an opinion as to how you should decide this case, you must pay no attention to that opinion. You judge the facts and you decide the case from the evidence. At times during the trial, I have excluded evidence that was offered or stricken testimony that was heard. Do not consider those things in deciding the case. Make your decision only on the evidence that I let in and nothing else. Your decision should be based on all the evidence, regardless of which party produced it. You should use your own common sense and general knowledge in weighing and judging the evidence, but you should not use any personal knowledge you may have about a particular person, place, or event. To repeat once more, you must decide this case based only on the evidence admitted during this trial. As I said before, it is your job to decide what the facts of the case are. You must decide which witnesses you believe and how important you think their testimony is. You do not have to accept or reject everything a witness says. You are free to believe all, none, or part of any person's testimony. In deciding which testimony you believe, you should rely on your own common sense and everyday experience. However, in deciding whether you believe a witness's testimony, you must set aside any bias or prejudice you may have based on the race, gender, or national origin of a witness. Now, there is no fixed set of rules for judging whether you believe a witness, but it might help you to think about these questions. Was the witness able to see or hear clearly? How long was the witness looking, watching, or listening? Was anything else going on that might have distracted the witness? Did the witness seem to have a good memory? How did the witness look and act while testifying? Did the witness seem to be making an honest effort to tell the truth? Or did the witness seem to evade the questions or argue with the lawyer? Does the witness' age and maturity affect how you judge his or her testimony? Does the witness have any bias, prejudice, or personal interest in how the case is decided? Have there been any promises, threats, suggestions, or other influences that may have affected how the witness testified? In general, does the witness have a special reason to tell the truth or a special reason to lie? All in all, how reasonable does the witness's testimony seem when you think about all the other evidence in the case? All in all, well, now sometimes the testimony of different witnesses will not agree, and you must decide which testimony you accept. You should think about whether the disagreement involves something important or not, and whether you think someone's lying or simply mistaken. People see and hear things differently. And witnesses may testify honestly but simply be wrong about what they thought they saw or remembered. It is also a good idea to think about which testimony agrees best with the other evidence in this case. However, you may conclude that a witness deliberately lied about something that is important to how you decide the case. If so, you may choose not to accept anything the witness says. On the other hand, you may think that the witness lied about some things but told the truth about others. You may simply accept that part you think is true and ignore the rest. Facts can be proved by direct evidence from a witness or an exhibit. Direct evidence is evidence about what we actually see or hear. For example, if you look outside and see rain falling, that is direct evidence that it is raining. Facts can also be proved by indirect or circumstantial evidence. Circumstantial evidence is evidence that normally or reasonably leads to other facts. So, for example, if you see a person coming from outside wearing a raincoat covered with small drops of water, that would be circumstantial evidence that it is raining. You may consider circumstantial evidence or direct evidence by itself, or a combination of circumstantial and direct evidence can be used to prove the elements of a crime. In other words, you should consider all the evidence you believe. You have heard testimony from witnesses who have given opinions as experts in certain fields. Experts are allowed to give opinions and report about matters they are experts on. However, you do not have to believe an expert's opinion. Instead, you should decide whether you believe it and how important you think it is. When you decide whether you believe an expert's opinion, think carefully about the reasons and facts given for the opinion and whether those facts are true. You should also think about the expert's qualifications and whether the opinion makes sense, whether you think the other evidence in this case. You have heard that a lawyer or a lawyer's representative talked to one of the witnesses. There's nothing wrong with this. A lawyer or a lawyer's representative can talk to a witness to find out what the witness knows about the case and what the witness's testimony will be. You should not decide the case based on which side presented more evidence. Instead, you should think about each witness and each piece of evidence and whether you believe it. Then you must decide whether you believe the testimony and evidence you believe proves beyond a reasonable doubt that the defendant is guilty. The defendant's intent may be proved by what he said, what he did, and how he did it, or by any of the facts and circumstances in this case. The prosecution has introduced evidence of claimed acts of violence by the defendant for which he is now on trial. Before you may consider such alleged acts as evidence against the defendant, you must first find that the defendant actually committed such acts. If you find that the defendant did commit those acts, you may consider them in deciding if the defendant committed the offenses for which he is now on trial. You must not convict the defendant here solely because you think he is guilty of other bad conduct. The evidence must prove to you beyond a reasonable doubt that the defendant committed the alleged crime, or you must find the defendant not guilty. You may consider whether the defendant had a reason to commit the alleged crime, but a reason by itself is not enough to find a person guilty of a crime. The prosecutor does not have to prove that the defendant had a reason to commit the alleged crime. She only has to show that the defendant actually committed the crime and that he meant to do it. The prosecutor also must prove beyond a reasonable doubt that the crime occurred on or about March 22nd and 23rd, 2016 within the county. Now, ladies and gentlemen, the defendant is charged in count 1 with the crime of assault with intent to prove this charge, the prosecutor must prove each of the following elements beyond a reasonable doubt. Now, there are three elements. First, that the defendant tried to physically injure another person. Second, that when the defendant committed the assault, he had the ability to cause an injury, or at least believe that he has the ability. And third, that the defendant intended to kill the person he assaulted. Now, everyone understands the elements of assault with intent to murder. Anyone want me to reread it? Okay. Now, the defendant can only be guilty of the crime of assault with intent to commit murder if he could have been guilty of murder had the person he actually assaulted died. If the assault took place under circumstances that have reduced the crime to manslaughter if the person had died, the defendant is not guilty of assault with intent to commit murder. Count two. Assault with intent to do great bodily harm, less than murder. You may also consider the lesser charge of assault with intent to do great bodily harm, less than murder. To prove this charge, the prosecutor must prove each of the following elements beyond a reasonable doubt. There are three elements. First, that the defendant tried to physically injure another person. Second, that at the time of the assault, the defendant had the ability to cause an injury, or at least believe that he has the ability. Third, that the defendant intended to cause great bodily harm. Actual injury is not necessary. But if there was an injury, you may consider it as evidence in deciding whether the defendant intended to cause great bodily harm. Great bodily harm means any physical injury that can seriously harm the health or function of the body. Everyone understands the elements of assault with intent to do great bodily harm, less than murder. Anyone want to read it? Moving on. Count three. The defendant is charged with the crime of unlawful imprisonment. To prove this charge, the prosecutor must prove each of the following elements beyond a reasonable doubt. First, that the defendant knowingly restrained another person. Restrain means to forcefully restrict a person's movement or to forcefully confine the person so as to interfere with that person's liberty without that person's consent or without lawful authority. The restraint does not have to exist for any particular length of time and may be related or incidental to the commission of other criminal acts. And second, the defendant did so under one or more of the following circumstances. The defendant is restrained by means of a weapon or dangerous instrument. The restrained person was secretly confined, which means to keep confinement or location of the restrained person's secret, or the person was restrained to facilitate the commission of another felony or to facilitate flight after commission of another felony. Everyone understands the two elements of unlawful imprisonment. Alright, moving on along. Count 4, assault with a dangerous weapon. To prove this charge, the prosecutor must prove each of the following elements beyond a reasonable doubt. There are 4 elements. First, that the defendant either attempted to commit a battery on the complainant or did an act that will cause a reasonable person to fear or apprehend an immediate battery. A battery is a forceful or violent touching of the person or something closely connected with the person. Second, that the defendant intended either to injure her or to make her reasonably fear an immediate battery. Third, that at the time, the defendant had the ability to commit a battery, appeared to have the ability, or thought he had the ability. And fourth, that the defendant committed the assault with a pistol. Everyone understand the elements of assault with a dangerous weapon. Anyone want me to review? Moving on. Count 5. The defendant is also charged with a separate crime of possessing a firearm at the time he committed the crime of assault with intent to murder and or assault with intent to do great bodily harm less than murder and or felonious assault. To prove this charge, the prosecutor must prove each of the following elements beyond a reasonable doubt. First, in the 2 elements, the defendant committed the crime of assault with intent to murder and or assault with intent to do great bodily harm less than murder and or felonious assault, which have already been defined for you. It is not necessary, however, that the defendant be convicted of the crime. Second, that at the time the defendant committed any of those crimes, he knowingly carried or possessed a firearm. A pistol is a firearm. A dangerous weapon is any object that is used in a way that is likely to cause serious physical injury or death. Some objects, such as guns or bombs, are dangerous because they are specifically designed to be dangerous. Other objects are designed for peaceful purposes, but may be used as dangerous weapons. The way an object is used or intended to be used in an assault determines whether or not it is a dangerous weapon. If an object is used in a way that is likely to cause serious physical injury or death, it is a dangerous weapon. You must decide from all the facts and circumstances whether the evidence shows that the pistol in question here was a dangerous weapon. An assault does not have to have that is, it does not have to cause an actual injury. However, if there was an injury, you may consider the injury with other evidence and determine whether there was an assault. I'm going to go back to count 5. Everyone understands the 2 elements of possession of a firearm at the time of the commission or attempted commission of a felony. Everyone understand those elements? All right. Moving on. Count 6. The defendant is charged with the crime of aggravated domestic violence. To prove this charge, the prosecutor must prove each of the following elements beyond a reasonable doubt. First, that the defendant assaulted and or assaulted and battered the complainant. A battery is a forceful, violent, or offensive touching of a person or something closely connected with her. The touching must have been intended by the defendant. That is, not accidental, and it must have been against the complainant's will. An assault is an attempt to commit a battery or an act that would cause a reasonable person to fear or apprehend an immediate battery. The defendant must have intended either to commit a battery or to make her reasonably fear an immediate battery. An assault cannot happen by accident. At the time of an assault, the defendant must have had the ability to commit a battery or must have thought or appeared to have the ability or must have thought that he had the ability. Second, that at the time, the complainant was the defendant's spouse or had a child in common with the defendant. And third, that the assault caused a serious or aggravated injury. A serious or aggravated injury is a physical injury that requires immediate medical treatment or that causes disfigurement, impairment of health, or impairment of a part of the body. Everyone understands the three elements of aggravated domestic violence. All right, moving on. The defendant is charged in count 7 with the crime of torture. To prove this charge, the prosecutor must prove each of the following elements of a reasonable doubt. There are 4 elements to the crime of torture. First, that the defendant had custody or control, that is, physical control, over the complainant. This means that the defendant used force or the threat of force either to confine her by interfering with her liberty or to restrict her freedom of movement. Second, that the defendant exercised custody or physical control over her without her consent or without lawful authority to do so. And third, that at the time the defendant had custody or physical control over her, he intentionally caused great bodily harm and or severe mental pain or suffering. Great bodily injury means causing a serious impairment of a body function, which includes any of the following: loss or substantial impairment of a bodily function, serious visible disfigurement, measurable brain or mental impairment, a skull or other serious bone fracture, subdural bleeding or bruising, or means internal injury, poisoning, serious burns or scalding, severe cuts, or multiple puncture wounds. Severe mental pain or suffering means a substantial change in mental functioning that can be perceived by another person. It must have been caused by the defendant in one or more of the following ways: intentionally causing great bodily injury to her or threatening to cause great bodily harm to her; administering mind-altering substances, or performing a procedure that would disrupt her senses or personality, or threatening to do so. threatening her with imminent death or threatening that another person will imminently be killed, subjected to great bodily injury, or given a mind-altering substance meant to disrupt the senses or personality. 4, that the defendant intended to cause her to suffer cruel or extreme physical pain or mental pain and suffering. The prosecutor does not need to prove that she actually suffered any pain. Everyone understand those elements? Now, I'm going to give you these elements, instructions that I just read to you for your deliberation. Now, if you believe that a witness previously made a statement inconsistent with his or her testimony at this trial, the only purpose for which that earlier statement can be considered by you is in deciding whether the witness testified truthfully in court. The earlier statement is not evidence that what the witness said earlier is true. Evidence has also been offered that one or more witnesses in this case previously made statements inconsistent with the testimony at this trial. You may consider such earlier statements in deciding whether the testimony at this trial was truthful and in determining the facts of the case. You have heard testimony from police officers. That testimony is to be judged by the same standards you use to evaluate the testimony of any other witness. Now, when you go to the jury room, you should first choose a foreperson. The foreperson should see to it that your discussions are carried on in a businesslike way and that everyone has a fair chance to be heard. During your deliberations, remember that a verdict in a criminal case must be unanimous. In order to return a verdict, it is necessary that each of you agree upon that verdict. In the jury room, you discuss the case amongst yourselves, but ultimately each of you have to make up your own individual mind. Any verdict must represent the individual considered judgment of each juror. It is your duty as jurors to talk to each other and make every reasonable effort to reach an agreement. Express your opinions and reasons for them, but keep an open mind as you listen to your fellow jurors. Rethink your opinions and do not hesitate to change your mind if you decide you're wrong. Try your best to work out your differences. However, although you should try to reach an agreement, none of you should give up your honest opinion about the case just because other jurors disagree with you or just for the sake of reaching a verdict. In the end, your vote must be your own, and you must vote honestly and in good conscience. counts 1 and 2, there are different crimes that you may consider. When you discuss those counts, you must consider the crime of assault with intent to murder first. If you all agree that the defendant is guilty of that crime, you may stop your discussions on that count. If you believe that the defendant is not guilty of assault with intent to murder, or if you cannot agree about that crime, you should consider the less serious crime of assault with intent to do great bodily harm less than murder. You decide how long to spend on assault with intent to murder before discussing assault with intent to do great bodily harm. You can go back to assault with intent to murder after discussing assault with intent to do great bodily harm if you want to. If you have any questions about the jury instructions before you begin deliberations or questions about the instructions that arise during the deliberations, you may submit them in writing to my bailiff. Possible penalty should not influence your decision. It is the duty of the judge to fix the penalty within the limits provided by law. If you want to communicate with me while you're in the jury room, please have your person write a note, knock on the door, and give it to my deputy. It is not proper for you to talk directly with the judge, lawyers, or other persons involved in the case. As you discuss the case, you must not let anyone, not even me, know how your voting stands. Therefore, until you return with a unanimous verdict, do not reveal this to anyone outside the jury room. When you go to the jury room to deliberate, you can take your notes. And if you want to look at any or all of the reference documents or exhibits that have been admitted, just ask for them. Now, the defendant is charged with 7 counts. That is, with crimes of assault with intent to murder, assault with intent to do great bodily harm less than murder, unlawful imprisonment, felonious assault, felony on firearm, aggravated domestic violence, and torture. These are separate crimes, and the prosecutor is charging that the defendant committed them. We must consider each crime separately in light of all the evidence in the case. You may find the defendant guilty of all or any one or any combination of these crimes or not guilty. On both sides approach the bench. deliberate and arrive at a verdict. And at this time, I clerk will draw the names of 3 jurors who will be excused with the thanks of the court.
The court wishes to thank and excuse juror in seat number 4.
And now, the judging person will allow me to
Wish to thank and excuse juror in seat number 6.
and excuse as well.
And we wish to thank and excuse juror in seat number 2.
Madam, again, thank you very much. Deputy, I'm sorry, Madam Clerk, you have the opportunity to swear that.
Do you solemnly swear that the firm will keep this jury in the manner prescribed by law?
I will.
Ladies and gentlemen, as I've indicated, I'm going to give you the instructions and verdict forms, which you will use for your deliberations. So the 3 excused jurors in the court. Now, ladies and gentlemen, you may retire to the jury room to begin with the deliberations. All right. You may be seated. I'm going to ask that you not discuss the case with anyone while the jury is deliberating, because you may be called upon to come back and serve on this jury. It's very unlikely, but just in case, I just want to make sure that you do not discuss the case with anyone, with your family, on yourselves, or the jury. The court's telephone number is at the bottom of the letter you received, and if you care to move on to court today, later on, about 4 o'clock, to see if you need it today. So you're excused, so once again, please do not discuss with anyone, and thank you very much for your service. All right, speak up.
Hmm?